These are the Bear Creek High School Honors Government Notes on the Judicial Branch. The Judicial Branch is found in Article 3 of the Constitution. That's where it gets they get their power. It's very vague and really much shorter than Articles 1 and 2, with less detail on what the judicial branch in the U.S. will actually look like, partially because our founding fathers weren't quite sure yet. But the one thing that we do know, and that is the most important power of the judicial branch, especially the Supreme Court, is interpretation of the Constitution. They interpret what it means and determine really where our freedoms lie and what is constitutional and what is not constitutional. From this graphic, you can see that the United States federal courts actually have several different levels. We mostly are going to talk about the Supreme Court because that is the National Court of Appeals. It is the final say in any court case, regardless of where it started. But as you see, there are many different levels of federal courts. We also have state courts and local courts. So when we say the Supreme Court, that doesn't mean all cases just go to the Supreme Court. The majority of cases that end up in the Supreme Court are appealed to the Supreme Court from a lower court decision. There are very few cases that actually start in the Supreme Court. Cases involving two states, cases involving ambassadors or representatives of other countries' governments will start in the Supreme Court, but generally, Supreme Court cases are appeal cases. So basically, the Supreme Court, like I said before, is the final authority in the court system. They hear appeals from other courts and determine whether or not cases really are constitutional or unconstitutional. They can change laws with this. If they declare something unconstitutional, the only way to get the law passed again is to make an amendment to the Constitution and change the actual Constitution. They can, however, go and change their own minds. For example, Plessy versus Ferguson said separate but equal was okay in 1898, 96. But then later in 1954, Brown versus Board of Education said it wasn't okay. So 60 years later, they did change their minds. Different court, different time period, that's okay. This is 9 people. It's 1 Chief Justice and 8 Associate Justices. 9 people who make up the decision on who will be, what is constitutional and not. They don't have to agree, you just have to have a majority on your side to win the court case. Originally, there were 6 judges total, 1 Chief Justice and 5 Associate Justices. This has changed over the years. You can actually add more. Congress has made this a little bit more difficult because in the 1930s, Franklin Roosevelt, when his New Deal programs to fix the Great Depression were being declared unconstitutional, tried to add extra Supreme Court justices in this move called court packing in order to get his programs supported. So Congress stepped in and didn't allow that. But at any time, we could add more justices if the President and Congress agreed that we needed more. So I mentioned that Supreme Court justices need the President and Congress to add them. Well, that's actually what they need to get their jobs in the first place. Supreme Court judges are appointed by the President and approved by Congress, specifically the Senate, and their term is a life term. The only way to lose the job is to die, resign, or actually be impeached. To be impeached, you actually have to do something illegal. It's not just because they don't like the job you're doing. So this really has good job security. This is also a way for presidents to kind of reach beyond their term in office, because if they are able to appoint Supreme Court justices for life, and a president only serves 4-year terms, the chances of that Supreme Court justice being in office for even decades after the president's no longer in office and that party has lost power means that many of those same policies they put in place will maintain for decades at the very least. Ideally, a judge would be nonpartisan. They're not a party person. They're going to look for constitutionality. That's our ideal. We want someone who looks at the Constitution, interprets it, and does not have their personal beliefs come into it. And many of them really try to do that. There are a few who do, we will see, that are sometimes partisan. So here you see our current 9 Supreme Court justices. You can tell the picture's been doctored a little bit. The 2 most current with their we'll call them fake pictures with little quotes there, are Sotomayor and Kagan. Sotomayor and Kagan were appointed by Barack Obama, so they're the most recent, and instead of updating the entire picture, we just pulled their pictures because we didn't have an overall picture of all of them. The two before that, actually our Chief Justice, John Roberts, was appointed by George W. Bush, as was Samuel Alito. He's number 5 on our picture. So George Bush served 8 years. He's no longer in office, actually almost 4 years out of office for him, and he still has 2 Supreme Court justices, including the Chief Justice. Now, the Chief Justice doesn't have any more voting power, but he does actually get to kind of run the court and help with the proceedings. So these are our current 9 Supreme Court justices. So I alluded to this idea earlier, like how cases reach the Supreme Court, but I didn't really go into detail. So you have 2 ways of getting into the Supreme Court. The first is original jurisdiction. And this means that the Supreme Court's actually the first court your case goes to. It is not an appeal. It's the first time it goes there. So any involving disputes among 2 states, because you can't have it in a state court, you go straight to the federal court, Supreme Court. A foreign ambassador who's accused of a crime, because that's dealing with the representative of a government from another country, those always go to the Supreme Court as well. You also have what's known as appellate jurisdiction. It means that the case happened somewhere else, someone feels that the response to the case was incorrect, maybe something was done incorrectly in the court, they don't agree with it, they feel it's unconstitutional, and they actually can then, the losing side can then appeal the decision, the verdict, up through the courts until they reach the Supreme Court. Sometimes they can go straight to the Supreme Court if they think it's a constitutional issue. Sometimes they go to the lower level courts first and work their way up. Now, when the Supreme Court hears an appeal, they get to choose to hear it. So there are hundreds and hundreds, well, thousands of appeals every year to the U.S. Supreme Court, and they get to decide which ones they hear. The justices do. So as you can see, there's between 5,000 and 7,000 cases appealed to the Supreme Court every year. Only 150 can be heard. They don't have the time to listen to all the cases. So they have clerks, law students. A lot of people, this is a really good job right after you get out of law school to clerk for the Supreme Court, because you can then get a job almost anywhere you want. So they read the cases, they pass on the ones they think the judges will be interested in to them, and then the justices review them. 4 of them must agree that it's a case they want to hear. Once 4 of them have decided they want to hear the case, then the case will be heard and put on the docket. Once they get to 150, they don't look at any more cases that year. You can, however, appeal your case every year until it gets heard. So for 50 years, you could write your appeals every year and ask them to hear it. They could turn you down every year, but you could do it. So as you see, we are just now in a new session in October. It'll go through June. They will look at the different issues and determine what the best course of action is for different topics. Some of those different topics are topics that really will matter to people. Some of you guys have been doing these controversial issues that you've been researching. Some of them are planned to be heard in the upcoming Supreme Court session. So if you watch the news, you listen to it, you'll actually hear some pieces about that. This leads us to the most important judicial power, judicial review. It's not really written into the Constitution that they have this power, but the Supreme Court has this power, and it's a very important power. Basically what it is they can review the decisions and actions of any of the other branches, the legislative branch and Congress, the laws, the president, executive branch, and actually determine if any actions that any of the other branches or departments, an agency or a state, any of that, has determined, they've made a law about it or said something about it, the Supreme Court can say, nope, that's unconstitutional, and nobody has to follow it. So this was a really weak branch up until Marbury versus Madison happened in 1803. And that's when the Supreme Court actually decided that this was the power they had. They kind of extended their own power to be that they could review other branches' actions. Because in Marbury versus Madison, they were reviewing actions of the new president and the Secretary of State, and declared that what had happened was actually unconstitutional. They also, in that case, determined that the law that Marbury was suing under was unconstitutional. So Marbury didn't win anyway, even though what the president did was unconstitutional as well. So they declared a law, Congress, as well as a presidential action, unconstitutional, and ever since then they have been able to set the precedent and review cases. This is their biggest power. They can be very strong if they decide to be what's called an activist court. And an activist court is just a court that makes decisions and really changes laws and impacts society. One of the big activist courts would have been in the 60s and 70s. We would call it the Warren Court. Earl Warren was the Chief Justice, and under Earl Warren, many different social issues, especially with affirmative action and equal rights, were passed or declared unconstitutional under the Supreme Court. Now, the Supreme Court hears actually both civil and criminal cases, mostly criminal though. But we have two different kinds of courts: criminal courts and civil courts. Criminal courts are the ones that somebody broke the law and they're going to go to jail, or they're going to be fined for breaking the law. So criminal courts are when someone is breaking a law and the government is going to charge them with a crime. Civil courts are a little bit different. These are ones between two different individuals. They're claims against the federal government. So when you talk about someone suing someone else or they're suing the government, that's actually going to happen in a civil court. Some constitutional rights will also show up in civil court as well. So if you felt your free speech was violated, you would sue someone for violating your free speech. That would go to a civil court. So anytime you're suing, a divorce, anything like that, that's civil court. Judge Judy is civil court. In fact, all of the TV judges are civil courts. People have given up their right to have a private court session. They actually choose to listen to the decision that she makes and go on TV. So that's how that one works. But she really is a judge, and she really does have a civil court courtroom and has the power to make decisions. And our last type of court is an appellate court. This is when, if you have a court case and you lose, and you feel like somehow this was not fair, there was a problem, maybe the judge gave incorrect directions to the jury, maybe there were procedures not followed, something happened that you feel was incorrect. Maybe even as the loser, you find new evidence that you think exonerates you or makes you not guilty. You can actually appeal and ask for your case to be heard again. This is not double jeopardy. If you remember back to the Amendment 5, double jeopardy, you're protected against double jeopardy. But because you're actually asking for it to be heard again. And the winner doesn't ask for this, the loser can ask for this. So then an appellate court can look at the new evidence, look at what happened, and actually either overturn the verdict, which means now the loser is the winner, or they can say, you know what, there was a problem, we're going to give you another trial. And they can have a trial again where they see it as being fair, they fix the problem that happened in the first one, and the person could be found not guilty, or they might be found guilty again. But this time they would have a fair trial if the appellate court found that it was not fair the first time. So that is the end of our judicial branch notes for today. Make sure that if you have any questions, you ask them in class. We will be talking about the Supreme Court and some Supreme Court cases that apply to you. So there are actually some student rights cases and things we'll look at in class. But make sure you understand how the courts work. So I'll see you in class tomorrow.